Well, I will assume that I can begin. Welcome to this session. Thank you for being here today. My name is Dave Levine, and I am a professor at Elon University School of Law, as well as an affiliate scholar at the Center for Internet Society at Stanford Law School. I also host a radio show on Stanford Radio called Hearsay Culture that focuses on intellectual property and technology law issues. I'm delighted to join you today, and my apologies for any of you that appeared yesterday. I did not have the information, which was my problem on my email end, to know that it was going. So I appreciate those of you who were here yesterday showing up today. Um, Today, I'm going to focus on what I consider to be an extremely understudied but extremely important issue involving our current challenges facing the COVID-19 pandemic, and that is the use of trade secrecy by pharmaceutical entities and others in the battle to create vaccines, diagnostics, and treatments. To do today in about 10 minutes or so is run through some of the issues that we have, and then I'll open it up for any comments, but I'll go about 10 minutes or so in the interest of answering any questions you have. For those of you that don't know trade secret law, this is kind of my slide that I use with my students that lays out generally what trade secret law is throughout the globe to the extent that countries have it. Generally speaking, to keep a trade, you don't want to disclose it, and the prima facie cause of action for in trade secret law is trade secret misappropriation. You're thinking about information that's valuable because it's not generally known, and particularly not known by competitors, and subject to reasonable efforts to keep it secret. The kind of famous formula for Coca-Cola is a trade secret, and therefore you can think about the Coca-Cola formula as the kind of information that traditionally falls in the world of secrecy. In addition to having something that's valuable, acquisition by improper means, which includes things like theft and bribery, are required for misappropriation. Again, the standard cause of action, followed by some kind of use or disclosure. Trade secret law operates in a way to cover virtually all information that would be potentially the subjects of patents, as well as much information that would be the subject of copyrights, and trademarks by definition generally wouldn't be trade secrets. But the point is that it's a much broader area than we see in other areas of IP, and that's why it's so important here. With that kind of framing for what trade secrets are, let's talk a little bit about going on in trade secret law more broadly before we turn to the issues associated with COVID. Um, Throughout the globe, both and additionally and importantly in the United States and the EU, we see trade secret law on the rise. The Defend Trade Secrets Act in the United States, which was passed a few years ago, creates a private federal cause of action for trade secret misappropriation for the first time. We've also seen recently amendments to the U.S. Patent Act beneficial to trade secret usage because of questions regarding patentable subject matter. Of course, there's an explosion of trade secrets litigation. The famous case involving Waymo v. Uber is a good example of it. But we also see in the United States a growing number of cases under the DTSA. And of course, anyone who's paying attention broadly to intellectual property and to the vaccine issues associated with COVID knows that there is a worldwide concern about information theft. This is where trade secrecy runs into particularly interesting challenges, because trade secrecy is fixed at the center of national security concerns, and therefore the misappropriation of trade secrets raises national security concerns for a variety of countries, including the United States. When you think about defense-oriented technologies, when you think about technology generally, it is trade secret misappropriation that is really very much at the center of concerns that countries have about protecting their intellectual property. And of course, speaking to a global audience, virtually every country that has a developed technology sector look at these issues. Lastly, and importantly, the EU recently passed the Trade Secrets Directive, which does create some interesting wrinkles in trade secret law that differ from the United States and other parts of the globe. But the point is that trade secret law is very much on the rise. So there's really two big issues that arise as we think about trade secrecy in the context of COVID. There's two questions that we need to answer. When do you have a COVID trade secret? And should access to that trade secret extend to competitors, particularly, but also the civil society groups, of which there are many involved with the global IP Congress. And I should note my thanks to the organizers for putting this together. And I've done talks in the past at American when we did these things live. And so I'm a big fan of what American University has done through PIGIP and InfoJustice, but also I'm grateful to our friends around the globe that do this kind of work. So when I talk about civil society groups, that's a different access point than competitors. And then, of course, there's a question of the public. But right up front, let's be clear about why this is an issue. Right? When we think about trade secrecy in this context, we're thinking about, right, four vectors that are particularly important. The first one is access itself, right? And by access, we mean very clearly, we're talking about access to these very vaccines, treatments, and diagnostics that might otherwise not exist. And they might otherwise not exist because of a related issue of affordability. Right, the challenge associated with creating these vaccines, creating these treatments, creating these diagnostics in a way that are affordable, not just to the wealthiest nations or wealthiest individuals, but to the entire globe. Of course, effectiveness plays a huge role in the context of the medical industry generally, and pharmaceutical companies in particular, and trade secrecy is at the center of that. And lastly, there's a question of scale. Right, we're talking about billions and billions of doses of vaccines that are not going to be all available at the same time, but we still need to scale up production in a way that would allow for, at least I think as a moral matter and a humanistic matter, for the entire world's population to have access. Trade secrecy is in the middle of this, and how does it come up? When you think about trade secrecy in this context, there are a lot of potential trade secrets within the world of COVID-19. Manufacturing processes and methods are a primary example of trade secrets. Test and effectiveness data are other trade secrets that exist here. Medical formulas. Formulas are classic trade secrets. Cell lines and assays. Also, biological information that can be treated as trade secrets. Genomic information about individuals, trade secrets. Very importantly, negative information, that is what doesn't work, also trade secrets. What do I mean by that? If pharmaceutical company A develops a process and that process turns out to be a failure, it would be valuable perhaps if other competitors knew that process failed, rather than proverbially reinventing the wheel or repeating research that's been done by others. Certainly from an effectiveness, from an access, from an affordability scale, right, the duplication of research would be particularly important and could move us faster. But negative information, what doesn't work, are also classic trade secrets. Combinations of generally known information, trade secrets. Technology platforms, trade secrets. And also financial information like sales projections. And it's very important to note now that I'm not suggesting in the work that I've done and running that I've done over the course of 15 years, although I'm focusing on COVID-19, I focus very much on this intersection of trade secrets and access to information, particularly from the perspective of accountability. That's a lot of the work that I did and have done through American University and PIGIP, working with Sean Flynn and Mike Palmedo and others, looking at when the public should have access to, for example, international trade agreements like TTP texts. But when we look at this list, I want to be clear that I'm not suggesting, nor do I argue, that all of this information should be shared with competitors, or for that matter with the public. In fact, that's not necessary at all. But some of this information, when we're thinking about a global public health crisis, and when we think about global goods more specifically, should be shared. Very, very importantly, when we go back to these questions, right? when do you have a COVID trade secret, and should access to the trade secret extend to competitors? It's very important to note, and folks at the Global IP Congress know TRIPS and Doha very well, so I can skip through the introduction and simply point out that there's very, very helpful language within TRIPS and Doha that I think is being brought and increased in front of the WTO that suggests that the flexibilities inherent in TRIPS and the Doha Declaration could be applied to trade secrecy. Articles 7 and 8 are fairly well known, that focus on technology transfer, as well as allowing changes to IP regimes for purposes of public health. But the Doha Declaration in particular is very promising. And it's very promising because there is actual language verbatim in Doha that says, and I'll just read it, right? We agree that the TRIPS agreement does not and should not from taking measures to protect public health, but it goes on to say, accordingly, while reiterating our commitment to TRIPS, we affirm that the agreement can and should be interpreted and implemented in a manner supportive of WTO members' rights to protect public health, and in particular, to promote access to medicines for all. In this connection, we reaffirm the right of WTO members to use to the full the provisions in the TRIPS agreement, which provide flexibility for this purpose. In other words, right, it seems certainly possible that one could argue that TRIPS and Doha in tandem really do encourage countries to take a more granular and I think a broader look at trade secrecy. If this is a matter and you say, okay, Levine, that's all well and good, but how is this going to happen? Well, this might be a way to do it. So what are the considerations in closing before we open up for discussion? What are the considerations that you want to think about here? Well, trade secrecy is an information access control mechanism, right? From voting machine code to the formulas used in fracking to vaccines. Trade secrecy prevents access to information. And in that way, trade secrecy is far more powerful than patents, copyrights, and trademarks in controlling not use, but access to information. As I already mentioned, trade secrecy and national security are hand in glove. And so unfortunately, in my view, particularly in the case of a global health crisis, national security can interfere with what otherwise might be viewed as positive information sharing. But also trade secrecy is granular. And by that, we're talking about the fact that trade secrecy is used by industries in different ways. In some industries, trade secrecy really doesn't create much in the way of any incentives. For example, in the furniture industry, because most furnitures can be understood and duplicated by virtue of looking at them, the furniture industry doesn't use trade secrecy that much. On the other hand, the chemical industry, as previously mentioned, uses trade secrecy heavily, and there is empirical research to support that. Trade secret stakeholders, right? Another huge issue, and one particularly relevant to this audience, right? Generally, we think of trade secrecy as involving competitors, right? And the only entities that are interested in trade secrets are competitors. Well, in fact, that's not true. That's not true not only because accountability and transparency, but it's also not true because in the case of a global health crisis, all of us really have an interest in how trade secrecy used and whether trade secrets are shared. And so trade secrecy, therefore, next bullet, is not sacrosanct. There's a couple of ways this could be approached. At the voluntary level, the WHO has the COVID-19 Technology Access Pool, what's known as CTAP, which is designed to create voluntary mechanisms for information sharing, although it hasn't done a lot of that, particularly in trade secrecy up to now. But also, it's possible, all right, although difficult, to create a compulsory trade secrecy licensing regime. And such a regime could actually perhaps, compel, right, directly the sharing of information with compensation that might not otherwise happen. And it's very important here to note that through all of this, I'm not suggesting that pharmaceutical companies even have to really in a way of revenue. In fact, I think because of consumer confidence, by virtue of information sharing and creating more effective vaccines, I think actually the pharmaceutical industry could actually make more money, since that's obviously a concern. And moreover, because of the billions of doses that are necessary in order for this to work well, we shouldn't expect that the pharmaceutical industry is not going to be able to not only recoup its investments, but make significant profits. Lastly, and I'm sorry to raise this alarm, but the next pandemic. Hopefully there will be another one based upon what experts have said. And we want to learn from, quite frankly, the errors that have been made in challenging COVID-19 so that we don't repeat them in the future. So let me stop here. I'm going to stop sharing and see if there are any questions that come out of chat or the Q&A. And if you do have any questions, you can go into the Q&A area, or yes, you can also simply speak and feel free to jump in. Well, recognizing that we only have a few minutes. Oh, I actually see one. I'm just about to jump in. I need a translation to the question, if someone could offer it to me. Alas, my knowledge of language other than English is limited. There's a question from Claudia Palaise. Yeah, is there someone who can translate the question for me? Thank you, Sergio. What is the relation between patents and trade secrecy in the production of medicines? Excellent question. Here's the nutshell. Generally speaking, patents and trade secrets act often as substitutes. In other words, entities choose to either patent, right, a given idea or keep that information as a trade secret. Increasingly, however, it's clear that patents and trade secrecy actually operate as complements. In other words, the relationship is that in the R&D stage, we see trade secrecy, particularly in areas where it's difficult to reverse engineer a given process, for example, that trade secrecy plays a big role, at which time when that trade secret is sufficiently developed such that it can render a profit, we see patents applied. That's number one. Number two on that question is that the relationship is one that also, right, operates to some degree in conflict. And what do I mean? In the production of medicines, obviously, right, once the medicine is ready to be marketed, that's where patents play a huge role, right? And I don't have to explain that any further. Trade secrecy, however, in the production of medicines is an extremely important part of appropriation, particularly where we have a new challenge, right? And the COVID-19 pandemic presents in many ways a new challenge, certainly a new illness. So when we think about the production of medicines, there is a fair point to be raised, which boils down to there's a lot more R&D that has to happen more quickly, which costs money. And so how do we assure that we have the incentives within the pharmaceutical industry, right, to make sure that these entities are able to, quite frankly, do the production that's necessary. That's why trade secrecy is something that has to be thought about very carefully. There is not the need to share every piece of information that is possible to be shared in this context, but to really take a very granular look at what should be shared. So for example, and I'm not an expert in vaccine or medicine development, but speaking to experts in that field, without question, production methods, cells, and things like that are necessary. Have they identified already protected trade secrets related to technologies from COVID-19? Yes. I mean, thank you for that question, Monica. The questions themselves that arise here are very much the focus of increasingly the civil society groups that are focusing in this space. I'm going to be doing a talk tomorrow for the Third World Network tomorrow at 7:30 Eastern Time, 7:30 a.m. Eastern Time on these issues. But the nutshell is they have been identified. The real challenge, of course, is getting the work done to encourage the pharmaceutical industry to actually solve these problems. I see we're coming up on 4:20. I just want to say, or 3:20 your time. I want to say very quickly, thank you for tuning in today. I'm happy to answer any questions that you might have on these issues. You can email me at dlevine3@elon.edu. That's DLEVIME3@elon.edu. Otherwise, thank you much. Thank you to the translators and to the control master and everyone else for putting this together. Be safe, be well, folks, and I'll hope to hear from you.